here shortly.
We're coming in quickly, Ian. It's kind of slowed, so I think you can go
Okay.
ahead and
All
start
right.
whenever you
Great.
want.
Sounds good. Thank you, Kelly. Good afternoon, everyone. My name is Ian Henderson. I'm the Policy and Systems Director here at Wakasa. Thank you for joining us today. Today is a sexual assault policy update, as you can see on the screen. So I'm going to be talking about or providing an overview of sexual assault laws that were enacted during the recent legislative session. Just for folks who are just coming in, a reminder, as folks came in right around 2, I let folks know that we are recording this webinar. So please know that, and we'll be sending that out. We had some requests from folks who weren't able to attend to record, and so this is an easy enough one to do that, and we'll be sending that out as a resource as well. So just know that we are recording it. Okay, so a little background about me. Many of you may know me. If you're not, I've been at Wakasa for now almost 19 years. And prior to coming to Wakasa, I spent my career after graduating from law school providing direct legal services to survivors of sexual assault and domestic abuse, both here in Wisconsin and in West Virginia and Massachusetts as well. So that's just a very little about me. Before we jump in, as you can see from the slide, right, that this session is really focusing on sexual assault related laws that were enacted during the most recent legislative session. It does not reflect all the bills that we engaged on during the session. And in fact, there's legislation that we spend a lot of time and resources on it, along with our partners, that is not going to be, I'm not going to be addressing. And those primarily relate to what we call intersectional bills that are important to our mission, but maybe where there is a partner organization who is leading the policy advocacy efforts on those bills. A lot of that in this past session, unfortunately, was working on and advocating against legislation. I think the best example of bills that I could give you on that front would be the transgender bills that were introduced and passed and thankfully vetoed by Governor Evers during the session. But that's not going to be the focus of today. We will, and I'm working on a full legislative summary that I will be sending out later this summer that will have all the bills that we engaged on during the session. But today we're really going to be focusing on those that are directly related to sexual violence, and either that we were leading the advocacy efforts on or supporting those bills and other bills that happened that we maybe weren't as active on, but that we think are important for folks to know about. So that I've also hyperlinked to the acts on the slides. Some of the slides you'll see, or some of the legislation. There's multiple slides just for ease and not overwhelming the slides with hyperlinks. If it's one bill that has multiple slides, the first slide of that particular bill will have the hyperlink. I think you'll be able to see pretty easily as we go forward. But that's there for when we do send this out, and for folks who may want to refer back to this as a resource, then it will take you right to the act. So, and I guess last thing I'll say, for those of you who have attended our policy calls that we hold in collaboration with End Abuse, this call will look a little familiar. Some of you may have heard about some of these bills because we were updating folks during the session in those spaces, but also know that, right, like not everyone attends our policy calls. And so this session or webinar will provide an overview of those bills. And I will be just kind of sharing and pausing periodically. I've got some of my colleagues, Kelly will be monitoring the chat, so feel free you don't have to wait until the end to ask a question. I'll pause excuse me, periodically to check in to see if there are questions. But yeah, you don't need to wait to the end. If there's a question you have, I'll do my best to answer it, and go ahead and either pop it in the chat or you can unmute. So without further ado, then we're going to go ahead and get started. So the first, I've tried to kind of group the bills that I'm going to be covering in a way that makes sense kind of thematically, right? So have a few sort of bigger buckets that I've organized these bills into. And the first one is improving system responses for survivors. Now you can see on the slide here, right, that's includes the criminal legal system, but it's not limited to that. So also address healthcare systems and the civil legal system as well. So the first bill that I'm going to reference is 2025 Act 90. There you can see that is the hyperlink when it has that sort of yellow text. This bill RAIN, which is the rape and abuse. Oh, I forget the complete acronym, but I think you may know who I'm talking about. One of the national advocacy organizations, anti-sexual violence advocacy organizations. They do some state work, and they were the ones who were primarily behind this particular legislation. We supported it, but this bill has three main things that it does. The first you can see here on the screen is extending the statute of limitations, and that's for second-degree sexual assault. It extends the statute of limitations from 10 years to 20 years. And also note that that extends the time period for the crime lab to store a sexual assault kit for survivors who are choosing not to report. And again, that extension is from 10 years to 20 years. The link there is to a Wisconsin Department of Justice bulletin, primarily for forensic nurse examiners. So I wanted to include that, and that's hyperlinked. But basically, what that bulletin says is that to give law enforcement time to take a report and request that a kit be tested, DOJ is encouraging survivors to make a report at least 6 months prior to the kit's permanent destruction date or disposal date. And so that information can be accessed through the kit tracking system. And again, right, that hyperlink has additional information for you on that particular part of the bill. Second, the legislation also extends some important amnesty protections for survivors. Under current law, a sexual assault survivor or a bystander may not be issued a citation or convicted of certain underage alcohol offenses if, right, they request emergency assistance in connection with a sexual assault and they cooperate with first responders. So, right, that's the current law. The Act 90 expands the scope of the crimes that trigger amnesty protections, right? So it now would include crimes like incest and any crime against a child involving sexual contact or sexually explicit contact. It also modifies the bystander definition to specifically include a witness there. Again, it's just kind of tightening up some language. And perhaps most importantly, it expands the amnesty protections to now include certain misdemeanor controlled substance violations, and that includes possession of drug paraphernalia. So this probably, if I had to give you my own opinion, was probably the most significant part of this legislation. Obviously, statute of limitations extension is absolutely important for survivors. This, I think, was I don't want to say the best thing, but like the biggest expansion for survivors, in addition to time periods that the state has to prosecute crimes, removing barriers for survivors for engaging with systems. These amnesty protections were really critical. For those amnesty protections regarding controlled substances, right, again, the survivor has to request emergency assistance related to the sexual assault or report it. There has to be evidence for a charge of sexual assault, right, as a result of that report, and then the victim provides their name and contact information and any requested information from law enforcement. So that is the amnesty provisions
Yeah, I
related to
tried to put
this.
a different speaker on, but I can't figure it out.
It's fine.
Oh, hey, just have folks mute themselves. Thank you. Yep, I was getting some background noise there. And last, related to Act 90, sorry, 290, sorry, Act 90 is making some changes to the lease termination provisions in current law, right? Currently, a sexual assault victim may terminate their lease early if they, one, face imminent threat of serious physical harm from another person, and they provide their landlord with a certified copy of an injunction, a criminal complaint, or a pretrial condition of release. So that's the current law. What Act 90 does is basically for sexual assault victims, it eliminates the requirement that they must show that they face an imminent threat of serious physical harm, right? They basically only need to provide the landlord with a certified copy of a harassment injunction or a criminal complaint based on sexual assault. It's not clear to me how much of a barrier that imminent threat of physical harm was for survivors. Obviously, this provision is not harmful. I think some of you who've been around for a while may remember that Wakasa and our partners at End Abuse had worked on housing-related legislation in previous sessions. We were trying to actually expand the kind of proof requirements that a survivor would have beyond injunctions and criminal complaints to allow an advocate to attest, right? Say, like, yes, I attest that this person is a victim of sexual assault or a victim of domestic violence. That legislation had been introduced for a couple sessions, but received a lot of pushback from primarily landlord lobbying organizations. So this bill doesn't address that. Again, I don't think it's harmful, but it's not clear to me how much of a barrier for survivors that having to show an imminent threat of serious physical harm was. But regardless, they no longer have to do that. And so now they only have to have either a harassment injunction or a criminal complaint. But again, right, either they have to file that restraining order, confront the person who harmed them in court, or, right, report to law enforcement. It's not even just enough to report, right? And then you have to have a prosecutor who issues a criminal complaint. So some of those things, particularly the criminal complaint piece, right, that's out of the survivor's hands. And yes, the survivor would then have to, if they wanted to take advantage of the lease termination provision, still have to file a restraining order to get out of their release early and have that injunction granted. Okay, and then Act 243. This was legislation that Wakasa has been working on for many years. I think it ended up being closer to 7 years, with the Department of Justice really trying to remove a barrier regarding the sexual assault forensic exam, or SAFE fund. The SAFE fund, when you the definition in the SAFE fund of reimbursable examination costs, the way that the statute was enacted, or the way it was drafted, did not include HIV prophylaxis. And so we worked on this legislation with DOJ, and were able to get it introduced and thankfully passed really pretty easily. It was introduced in the fall of 2025 and passed both houses earlier this spring. So we were really happy to see that move so quickly. But now it makes it clear that reimbursable examination costs include HIV prophylaxis. Now, we kind of view this as step one of our SAFE Fund reform related to HIV prophylaxis, because currently in the SAFE Fund, there's an administrative rule that has a cap on reimbursements to healthcare providers. So we are aware, we'll continue our dialogue with our partners at DOJ to look at administrative rule changes to either raise the cap or to create a specific cap for HIV prophylaxis, but that's going to be kind of step two in the process. But again, with this legislation, thankfully, now makes it clear that HIV prophylaxis is a reimbursable cost. And yes, Act 246, also legislation that kind of was introduced relatively late in the session, but had a lot of momentum, and want to just give kudos to folks in Brown County. There was a really good multidisciplinary group of folks who came together, advocates, law enforcement, the district attorney's office, folks from the Child Advocacy Center, to address and to make some reforms to existing law regarding the ability of a prosecutor to use audiovisual recordings of statements of child victims. So under current law, right, a prosecutor can introduce an audiovisual recording of an oral statement of a child victim in the following circumstances, right? You can see for children under 12, the court must admit the audiovisual recording if the trial or the hearing happens before the child's 12th birthday or between the ages of 12 and up to 16. The court may admit the statement, right? So that obviously the court has some discretion there. They would have to find that the hearing would have to happen before the child's 16th birthday, and the court would have to find that the interests of justice warrant the admission of the recording. Just to be clear, right, in either case, right, if the recording is introduced, the child must still be available to testify, and that includes cross-examination. One of the things that Act 246 makes some really significant changes, and I think what we heard from the folks in Brown County was that due to delays in the criminal legal system, right, you might have had a recording that was made when the child was 13, for example. But by the time the case got to trial, that child was maybe 16, right? And in which case, the DA's office could not use that audiovisual recording. And so, we all know that at 16, barriers regarding testifying, impacts on child victims and going through the court process. Just because someone's 16 doesn't mean they're all of a sudden ready and able to testify without experiencing trauma. We know that the criminal legal system can be traumatic. And so this legislation eliminates the requirement that the admissibility of the recording depends on the age of the child at the time of trial or hearing, right? Instead, the court must look at the age of the child at the time the recording was made, right? That's to try and address that issue that the delays in the criminal legal system, which are no fault of a child victim, right? They don't have any control over how quickly or slowly the criminal legal system moves, right? The age of the child at the time the recording made is going to be the important age, and right, this also expands the court's ability to admit a recording if up to including 16 and 17-year-olds, right? So previously, right, once you hit 16, those recordings could not be introduced. Now, if that could include 16 and 17-year-olds, again, it's not automatic. The court would still have to find that the interest of justice warrant the admission. But that's a pretty significant expansion as well, right? And again, as I mentioned, the child victim must still be available to testify, including on cross-examination. And the last bill I will talk about regarding improving system responses is Act 22. This is legislation that has been around also for a while. It requires hospitals to obtain the written informed consent of a patient before a pelvic exam is performed solely for educational purposes, right, while the patient is unconscious. There had been some reporting nationally and in Wisconsin of a practice at hospitals that while someone was unconscious, undergoing a procedure, that pelvic exams were being performed again for training purposes uh, for doctors. But coming from a body autonomy and a consent, the importance of body autonomy and consent, right? This legislation sort of reinforces those and upholds those important principles by saying, hey, hospital, you have to have that person's written informed consent before a pelvic exam is performed for educational purposes, and again requires hospitals to develop policies on that practice as well. And so that was able to get over the finish line after several sessions. So I'm going to just pause there before we shift gears to the next kind of bucket of bills to see if there's any questions.
No questions in the chat yet, Ian, but people are welcome to unmute as well.
Okay, well, I'll keep going then. And again, I'll be pausing and we'll certainly pause at the end as well. So the next group of bills I've kind of lumped under the technology facilitated sexual violence umbrella term. And first is one that I'm sure folks heard about is the creating a crime of sextortion. This is Act 48. It was also, excuse me, known as Braden's Law, referencing a child sextortion victim who unfortunately died by suicide, and his parents were really active in the passage of this legislation. So sextortion, right, under the new law, references threatening to injure the property or reputation of someone with the intent to coerce them to engage in sexual contact or producing an intimate representation of that person. It also references threatening to commit violence with the intent to coerce someone to engage in sexual conduct, excuse me, or producing an intimate representation, or threatening to distribute an intimate representation with the intent to coerce someone to, and again, you can see here, right, engage in sexual conduct, produce an intimate representation, provide payment, or to basically do or refrain from doing anything against the person's will. So this, generally speaking, someone who's convicted of the crime of sextortion would be guilty of a Class I felony. It can be bumped up to a Class H if the victim actually does any of those things, right? This legislation includes threatening to do those things, but if the victim does produce an intimate representation, right, it can bump up to an I felony. Also, if the victim is a child and the person is, uh, excuse me, not more than 4 years older, it could be a Class H as well. It can get up to a Class G, right? So it goes from up to A. A is the most serious felony. So it could bump up to a Class G if the person had a previous conviction for a sexually violent offense, or again, the victim was a child and the person engaging in the sextortion was more than 4 years older than the child. Also expands crime victim compensation eligibility for victims of sextortion. And that includes in cases where the victim dies by suicide, right? And that the crime of sextortion was a causal factor in the victim's death. And a companion bill, which we were really happy to see. You know, we have that creating the crime. Obviously, that's one piece, but we know the criminal legal system isn't the be all end all for all survivors. Act 215 created a civil cause of action for sextortion, right? Making it clear that a case can be brought by either the injured person, the person who experiences the harm, a parent in a case involving a child victim, or a personal representative if the victim is deceased, right? And it also creates an exception to the general rule in wrongful death, civil cases, right? That those actions aren't available if someone dies by suicide. Uh, this legislation creates an exception that if the sextortion was a substantial causal factor in the suicide, then a wrongful death action may be filed. And we also had Act 234. Probably have heard the phrase term deepfake, right? Basically, right, someone using technology to create a intimate representation of someone that's not real, right? You're putting someone's actual face, right, on a image of someone engaging in an intimate act or someone who is nude. This legislation criminalizes those quote unquote synthetic intimate representations, also known as deep fakes, right? And you can see there the language using an identifiable person's face or likeness to depict an intimate representation, and which is so realistic, right? That a reasonable person would believe it was that individual. There's a lot of media attention on this. We've shared some articles on this on our social media recently. So no, this is something that has been attracted a lot of attention both in state legislatures, in Congress, and so Wisconsin passed Act 34 that makes it a Class I felony to post, publish, or distribute a deepfake with the intent to coerce or harass that person. Last thing on the technology facilitated sexual violence, just mentioned that There were three bills that were enacted related to internet crimes against children. That included an appropriation for ICAC, right? That's the acronym for Internet Crimes Against Children, position authority for DOJ, and the ability to use administrative subpoenas in sextortion cases. So that's the technology facilitated sexual violence portion. I will just pause again, see if there's any questions in the chat or anything coming up for folks before we move on.
Hi, Ian. Jane from Women's Community.
Hi, Jane.
Is there a crime of taking photographs of someone without their consent? Say, for example, someone is sleeping and their partner takes a photograph of their naked body without their consent. Is that, where does that fall?
Yeah, it's a good question. I believe there's existing law that covers that. That is an area of the law that has evolved a lot over recent years, and there's legislation about, taking a photo of someone where they have an expectation of privacy and they weren't consenting to a photo that maybe showed them nude or something like that. That is included in existing law. I don't remember the exact name of the crime, but yes, I would say yes, that is already covered in Wisconsin law.
Great, thanks. I thought
Yeah.
it was, but I just couldn't remember for sure.
Yes, I can't remember the name of the statute, but yes, yep. Good question. Thanks, Jane.
No questions in the chat right now,
Okay.
Ian.
Okay.
But again, please, folks can either drop them in the chat or unmute.
Yep. Thanks, Kelly. Okay, well, I will just keep going. Educator sexual misconduct, right? A issue that has received a lot of media attention, particularly in the wake of some really good investigative reporting done by the Cap Times, right? Those stories kind of came out in the fall of 2025. Some of the bills were already were already in the works, I guess, for lack of a better word. Before that reporting came out, and some of the bills came out were certainly a response. But I'm just going to cover the bills related to educator sexual misconduct, and again, not even just in this session. In previous sessions, right, we had a crime created regarding sexual misconduct by a school staff member, so that crime was already on the books, and that was from the previous legislative session. So Act 257 sort of takes that the next step by requiring parental notification of suspected sexual misconduct by a school staff member. So again, this references that existing crime of sexual misconduct by a school staff member and requires notification if the person who receives the report determines there's reasonable cause to suspect that the alleged misconduct occurred. That language may sound familiar to folks who know about mandatory reporting, right? That basically parallels or takes the language from mandatory reporting, that reasonable cause to suspect. So uses that in this particular legislation as well. So that's similar to the mandatory reporting language, which means, right, like that discretion is built in, that the person who receives that report has to have a reasonable suspicion that the misconduct occurred. And if they do, right, then they must notify the parent or guardian of that student. Act 89, sometimes people say like, well, do we really need legislation on this, right? Why do we have to have legislation requiring school boards to adopt policies on appropriate communication between employees and students? I mean, I think the short answer is because we've seen many, many cases, unfortunately, of abuse of power by educators, right? And again, right, to be clear, are educators the only people who abuse their power and engage in harmful behavior with students? Of course not, right? And right, there are examples, unfortunately, of that happening, and we know the power imbalance between a student and educator exists, right? And where that exists, we know that can also be ripe for people exploiting that power and engaging in harmful behavior to students. And so this legislation, Act 89, requires school boards to adopt those policies on appropriate communication, that has to specify appropriate content and methods of communication with students, um, specify a range of consequences for violating those conditions, including termination, and requiring annual training on preventing, identifying, and reporting grooming and professional boundary violations. So again, right, there's a prevention component to this legislation as well, which is important, right? And that the Department of Public Instruction has to develop free training on this topic and make it available. Also related to DPI is Act 185. Again, right, those of you familiar with that cap times reporting, aware of the kind of um, lack of transparency, I guess I will say, regarding complaints about people who are licensed educators. This requires DPI to maintain a licensing portal on their website, allowing the public to search and access that license information by name, and that has to include information related to revoked licenses and licenses under investigation. Also including information about the outcome of the investigation, including if that license was voluntarily surrendered during investigation. So again, increasing transparency, I think, is the underlying theme here with this legislation. One of the things that the cap times reporting sort of brought to light was practice of educators who are facing discipline regarding their license, facing license suspension or maybe termination or revocation, saying, well, I'll surrender my license as a way of just kind of ending the investigation. This licensing portal would have information about licenses that are surrendered during investigation. Last one I will touch on related to this is Act 186, which prohibits school boards from entering into confidentiality agreements. Right? It requires school boards or prevents them from signing agreements. Sorry for the awkward wording on the first part there. Basically prevents them from signing agreements during surrender or termination that would suppress or destroy information relating to an investigation for immoral conduct. That's where a lot of the sexual misconduct is going to fall under this immoral conduct language in the licensing process, that would impact the ability of someone to report the immoral conduct, or somehow would require the education employer to expunge information about the allegations or findings. So again, trying to address the ability of someone who's accused of harmful behavior to say, I'll surrender my license, but school board, you can't share that information. As a condition of me surrendering, you'll agree to not share any information about that. Again, right, not wanting, and something we've seen, right, is, educators who are accused of that behavior going on to other schools, and parents not having any knowledge that that person, or that maybe the school future employer doesn't have knowledge about that person's past and the allegations against them. So I'm gonna pause. I do see a couple of things in chat and just see if there's any questions, and then we'll move to the last bucket.
Some conversation, so I won't. People
Okay.
can read that. There was a question: where are they getting the definition of immoral from?
It's in Wisconsin law. It's in the chapter regarding DPI. I don't have the exact language in front of me, but know that immoral conduct has a definition. And so it's in Wisconsin law. I just don't have that specific language right in front of me. It's in the educational chapter for that. That's where that is. Anything else, Kelly?
No, that was the only question.
All right. And lastly, and again, right, there's some overlap with some of the categories here, right? We've already talked about sextortion as a new crime related to sexual violence. So, but but it's also technology facilitated sexual violence. But there were some crimes related to that were created this session. And grooming, right, is one of the big ones. Act 88 creates the crime of grooming of a child for sexual activity. You have the link there. I'm going to spend not much time on this one, not because it's not important, or not because we don't think there's good content to unpack regarding not only the crime, but grooming behavior itself. Just a couple quick highlights before I share a little more information about our plans related to grooming. Not plans related to grooming. You know what I mean. Plans related to training on the topic of grooming. There we go. That expands the statute of limitations for this crime, right, or creates a statute of limitations to allow prosecution till the victim reaches the age of 45. Has sex offender registry requirements. Grooming is now included in the definition of abuse for mandatory reporting. And as you can see, right, that we will be putting on a webinar on grooming that will include, but not be limited to, the legislation that was enacted later this year. So I'm not going to go through the statute in great depth because that would be something that will be a part of that webinar. But again, when we do the training on grooming, we want to expand it beyond just this legislation, talking about grooming as a concept, why it's important to address that, talk about prevention related to that, and also talk about how the language around grooming, right, has been co-opted in really harmful ways, particularly harmful ways against the LGBTQ plus community. And so acknowledging that. So stay tuned for more information on that and look for that coming in the future. So, but again, right, this was a significant new crime that was created this session. And the last one I'm going to touch on is basically a penalty enhancer for sexual violence against an individual at risk. And so this creates, basically would bump up a case from a charge from second degree to first degree when a person commits an act that would be second degree of sexual assault, secondary sexual assault against an adult at risk. Right. And that adult at risk, the definition of that is, any adult who has a physical or mental condition that substantially impairs their ability to care for their needs, or is at risk for experiencing abuse, neglect, self-neglect, or financial exploitation. So again, right, if it would, there would be a case reported that would be a second degree sexual assault and that the victim was an adult at risk, it would now be elevated to first degree. There's already an existing penalty enhancer for a case involving a victim who is an elder at risk, right, which is a person age 60 or older, also with experience whose age impairs their ability to care for their needs. Sort of very similar language, and this sort of just expands that from it being limited to elder at risk to now include an adult at risk. And again, it's not really a new crime. It's more a penalty enhancer of raising the charge from second to first degree. Okay. And that's what I have for you all today. So I'll just pause to see if there are any questions. Again, we'll be sharing the recording. That will make sure that will include the presentation as well, a PDF of the PowerPoint. But if there are any questions, I'm happy to hang on and try and answer them.
We got a question in the chat, Ian.
Okay.
Is second sexual assault the only crime that the evidence collection extends to 20 years?
Is second degree sexual assault the only crime? I'm sorry, can you just repeat that?
I think that's I'll read it exactly as it says. Okay. Is second sexual assault, so I'm guessing maybe the only crime that the evidence collection extends to 20 years?
I'm just going to go back to the slide and hopefully that will answer the question. Maybe the person can unmute. Sorry for the
sorry, it's me, and I went typing too fast.
It's okay, Jess. Uh, right. It extends the statute of limitations for second degree. Yes, it's only second degree from 10 to 20 years. That's the only place that
Okay.
that legislation made the extension.
Yeah, that's what I thought. I just wanted to make sure.
Yeah. Yep.
Okay,
Yep.
thank you.
You bet. Any other questions?
This is Danielle from PDC. So when they have changes in legislation and there's charges that have been turned over to a DA, for example, but they haven't pursued the criminal justice process, when or how in that process are things turned over to the new legislative acts?
Okay, I think I understand what you're asking, Danielle, is like at what point do these new things come into play? Is that kind of what you're asking? Just want to make sure I'm
Yeah.
understanding. Yeah, good question. The very short answer is usually it depends on the language of the act itself. In the act, let me just pull up an example here, and hopefully usually it applies to. It's not retroactive, I guess is the another part of the short answer is usually it applies to acts that happen after the date of enactment. So are you all seeing, Kelly, can you just let me know, are you seeing the act or are you still seeing the slide?
Nope. I'm seeing what you're trying to show us. And maybe if you want to zoom in a little bit, that might be helpful if you can.
Yeah. This is probably going to be a bad example because it's more complicated, but this is one example, right? Of course, it has some notwithstandings. Yeah, I picked a really complicated one, of course. Let me not use this one because it's getting into the statute of limitations. Let's use, just bear with me. Let's use sextortion. Okay, hopefully you're seeing
Yep.
this long. Are you kidding me? Uh, where's yeah, this is great. So what happens when I try and do it on the fly here? Usually there's language about when, and of course I don't see it here. It is generally the very short answer, and rather than keep on picking bills, and undoubtedly they're always going to be the wrong ones. It's things that happen after the date of enactment, and so you can see on this one, for example, date of publication, December 9th. So crimes that occur post December 9th, acts that occurred post December 9th would generally be right when the new law applies. So that's kind of the start date. Sorry for I thought I would be able to give a really clear example and failed in that. But that's generally the answer. The statute of limitations is more complicated. I just shouldn't have picked that one. So
That's
does that
okay.
make sense, Danielle?
It does, yeah. So I guess my follow-up to that is now that the statute of limitations for second degree sexual assault have been
Hmm.
expanded, if
Yeah.
people didn't report within their 10-year window, but now they're within their 20-year window,
Yeah.
are they still able to delete a report?
That's the really complicated answer, which
Okay.
I'm going to say I'll try and answer quickly, although it's very difficult to give a short answer. I mean, ultimately, that's going to depend on the facts of the specific case. Ultimately, the DA is going to be the one who's going to have to make that decision. Generally speaking, right, in criminal system, right, it can't be retroactive. So if the extension, it can't revive cases that were barred at the date of enactment, if that makes sense, right? So if, for example, my case had a statute of limitations, it ran out, right, after 10 years. But it ran out in 11 years, right? And now it gets extended to 20. Would that revive my case? The answer is no. It's not retroactive, right? And basically, but if it didn't run out, and then the new time applies, right? So it can extend it, it can't revive it is the best way I know to answer it, if that makes sense.
Yes, thank you.
Okay. Other questions? Good ones, hard ones, but good questions.
It would be boring if you just had easy ones to answer.
Right.
Right now, no others in the chat, but I appreciate people unmuting as well. So please continue to do that.
All right. Well, if there aren't more questions, then we can go ahead and I can give you back another almost 15 minutes of your day. And just want to thank you all for joining today. Appreciate your questions. Appreciate you being here. As I mentioned, we'll be sending out the recording of this training, um, including the PowerPoint. So you'll have those, and we'll have those hyperlinks. And just know that, right, like we're a resource here, happy to answer questions that might come up after the fact. Know that I'm working on our comprehensive legislative summary. We'll be sending that out on the listservs yet this summer. And then, as I mentioned, also for the grooming webinar, that's something we are planning on offering. Don't have a specific date for that yet, but stay tuned on that. And again, thank you all for being here today and have a good rest of your day.
Thank
Bye,
you.
everyone.
That was really helpful.